when you're asking any questions. Okay. All right. Without further ado, please take it away, Tesh.
Thank you very much. Thank you for the introduction, and I'm glad to present this work. And thank you for coming, everyone. I see Robert writing there. He's not seeing me, so I don't know what's going on. I think everyone can see me, right? Right? Yes. For some reason, he's not seeing. Oh, he's not seeing the speaker. Probably he's not seeing Blair. So okay. Oh, you do now. Okay, good. All right, great, Robert. All right. Okay. All right. So this is a project I worked on over the past couple of months, beginning from the spring term over the summer. And it ended up being a huge paper, about 85 pages long. And initially, the title was a different title. It was Data Governance in Agriculture under a framework, under a data governance framework. And then after I presented as a work in progress in an intellectual property forum, I decided to split it into two, one focusing on the connection between copyright and privacy, and another developing it into a data commons approach, governance approach with respect to agricultural data separately. So this has been refined, and it has been submitted to a journal, and is forthcoming with Vanderbilt Journal of Entertainment and Technology Law. It looks into both US and Canadian copyright law in trans-jurisdictional context, and it proposes that kind of a framework that's applicable to both jurisdictions. So as you can see, the title, it looks into the intersections between copyright and privacy in the context of the big data era, but it specifically looks into technology users' data in various realms. But the paper is grounded on specific reference to agricultural data. So that is the background, that is the context in which the paper is written. But the analysis could apply, and that's part of the inquiry that I propose later by the conclusion. Could this apply to other sectors of data? But I found agricultural data to be an interesting category of data for this analysis. So you would see examples of agricultural data in the presentation. To start, just as a background, we have a transforming digital landscape, specifically with respect to agricultural data, as well as in other areas of economic performance. So with respect to agricultural data, we have what we call precision agriculture. In medicine, we have precision medicine as well. And these are technological methods by which data are being used in a digitalized format to provide, in the context of agriculture, to provide site-specific management of farm inputs, in the context of medicine and other applications, to provide personalized and individual-specific information. So there is a significant level of digitalization led by early stages of the technology. This precision agriculture or precision medicine basically started in the 1990s. It's an early technology. But then we have more recent technologies, the Internet of Things, sensors that collect all different kinds of data, from wearable technologies with respect to our body, with respect to our health, or from sensors mounted on the refrigerator, or in the context of agriculture, on sensors mounted on tractors. There will be at least 140 sensors on a new combine harvester and about 60 sensors in a new size set of our tractor. There are data collected from drones, data collected from satellites. And then we have a third set of technologies that's contributing to the transformation of the digital landscape, the data platform and farm management software applications that are enhanced through the application of machine learning and data analytics to provide what is called predictive and prescriptive analytics. So all this data is used by data platforms, by software platforms such as Climate View or others. There are a number of them in the market. Most of them acquired by traditional agricultural input providers such as Monsanto, Bayer, etc., that use all this data and are engaged in at least in these two specific activities: predictive, what would be harvested in the next year in this land, what would be most productive production on this land, and prescriptive analytics, just selling to the farmers what should be, based on all this processing of data, what input should be the farmer be using, or what kind of crop should be producing. So there is that whole landscape. So with the context of access to data and control arises in the context of two categories of data. So we have raw data that's collected directly from the source, and we have processed data. Raw data could be of any of these three categories. We have technical data, data of a technical nature, collected from the land, for example, about the nutritive value of the soil, the moist level of the soil, the yield nature of the soil, etc., or the human health state. That is a data of a technical nature that has significance for practical application. Then we have machine and device data that is automatically recorded in the operation of the machine. How the machine operated, self-autonomous machines are abundant in the agricultural field, smart cars collect all different kinds of data about the tractors or the cars or the heart valves functioning, all those different kinds of machines. And then we have the third category of data, activity data. That is when farmers or patients or individuals enter data into a data platform through keystrokes. So these are all three different kinds of data. They are generally called raw data. Then we have what we call processed or analyzed data. These data are analyzed and purified and cleaned and put in a usable form in this form. So the question of access to access and control over data arises in the context where individuals share raw data, and that data comes in the form of processed data, and they want access to that processed data, or they want control over the data they have contributed initially. So there are two contexts in practical sense. In the context of diagnosis and repair, for example, there are technology protection measures and software copyrights on machine and device data that restrict farmers from accessing data. So you have heard in the news, farmers hacking their own tractors to access that data because it is locked out, or farmers fighting with John Deere over whether they can fix their tractor or whether they should fix it. They have to fix it according to John Deere on authorized sellers. So that is a significant issue for farmers, but it's a significant issue for consumers as well. I use the farmers context because it has become prominent, but it has that general level of application. Another context is farmers need data just not to repair and diagnose, but for decision making on their farm, or patients for decision making on their health. And that data is limited. Access to that data is limited through click-through and click-prop licenses. These are ways of enforcing copyrights by selling access to the data. So therefore, farmers are, despite the abundance of data because of this transforming landscape, farmers are confronted with a data drought. A lot has been written about how farmers have had encountered this problem. The more serious aspect of control over data is who has access to that, to whom would that data be transferred? Would these data originators have control over data? And this lack of data has significant commercial and economic and privacy implications, and we have seen that in the context of an ongoing dispute court proceeding in the chicken industry in the United States, whereby a certain database company collects all different kinds of data from farmers, from retailers, from processors, and pass it into wholesalers, and wholesalers and other actors, upper ecosystem actors, use that data to reduce the price of chickens, the salary of farmers, and to increase the price of chickens based on that collected data. So it has a significant economic implication, that lack of control over to whom the data will be transferred. So the question then is, well, what does the existing law provide? The existing law provides a mechanism under what is called the Fair Information Practice Model. So the Fair Information Practice Model generally are implemented primarily through contractual methods. Contractual methods are not effective to empower farmers to have access, otherwise to have control, even though usually in contracts, farmers are deemed to be owners of their data. In practical terms, the contractual provisions in itself do not entitle them to full ownership. So what's ownership in a contractual context is a very difficult concept. There are a number of practical difficulties in private choice that makes ownership of data difficult in a contractual context. There was a study in Australia conducted whereby 74% of farmers didn't know much about the terms and conditions related to data collection in the agreement with service providers. So they wouldn't know, even if they are called in the contract owners of their data, they wouldn't know what the implication is. There are information barriers from structural imbalances. Sometimes farmers would just have to accept it because they will have to buy the technology and they'll have to accept the terms of the contract. And there are limitations of the contract law as being applicable between two parties. If the data is transferred to third parties, subsidiary parties, then they don't have any remedies. In the context of privacy law as well, the paper looks into limitations of privacy law in many contexts. The PIPEDA, the Canadian Personal Information Protection and Electronic Documents Act, the EU GDPR, as well as the California Consumer Privacy Act are mechanisms of dealing with it. But they have also their own difficulties, definitionally, in a technical sense, as well as scope-wise, and finally, doctrinally, because these are the harms that occur to farmers or to any actors in any other economic sector are more than the kinds of harms that privacy is conventionally designed to compensate for. So there is generally a lack of legal regime or remedy to farmers to ensure access and to control the distribution to third parties. In this context, copyright plays a significant role. Copyright plays a significant role from the context of upstream actors, technology providers, data intermediaries, and data platforms, those who collect data, process data, and use data, exercised access, what is called access right in copyright. Access right means exercise of technology protection measures and software control, just directly limiting access, or they exercise copyright control, either arising from contractual stipulations. Even though farmers own their farmers, they say we own and will hold copyright in the particular formats and manners of presentation we use to display the present your data. So basically, the way the data is presented after it is collected is controlled by copyright. Statutory copyright is also another instrument, in a sense that there are jurisprudential changes that enable data ownership. So at least in the United States as well as in Canada, raw data is not a subject of copyright. That much is settled. But processed data, there is emerging jurisprudence, at least circuit level court decisions in the United States, and Alberta Queen's Bench decision that in which appeal to the Supreme Court was denied, have provided a way by which processed data can be copyright protected. Besides that, data can be copyright protected as a compilation in aggregate. So my hypothesis is that in these circumstances where upstream actors control user data under copyright, we need to have a trust model of data governance by which data originators, such as farmers, are accorded certain rights in a sui generis law modeled on copyright to ensure trust in data sharing. That hypothesis is based on the normative rules of copyright. So generally, the relationship between copyright and privacy is considered to be disparate. Copyright is about free distribution in the interest of the public in terms of normative model, whereas privacy is about restriction of information. So there is a whole lot of scholarship examining and criticizing the use of copyright for privacy, but there are emerging jurisprudence. There is emerging jurisprudence largely in the United States, as well as there are roots in the copyright law, in common law copyright, that suggests that copyright can be a legitimate instrument for protecting privacy. There is what is called privative claims in the common law copyright that are subsumed under the Canadian right of publication and public distribution rights. These rights are self-standing rights, and they have been used in recent times as a means of ensuring privacy, controlling privacy by using copyright. So there are at least 4 circuit level decisions in the United States whereby individuals wanted to prevent unfavorable subject depiction in the picture. So a tabloid would take a picture of a celebrity in some compromising position and they won't publish it, but then these individuals, these celebrities, subjects of the copyright, would assert copyright over the picture and then ensure privacy is protected. So there are at least 4 decisions. There is also in the scholarship, there is a basis for the use of this jurisprudence as a means of combating revenge porn. Usually revenge porn involves subject depictions. It could be a selfie. So a selfie, someone who took a selfie has copyright over the picture, so they can control the distribution of that copyright over the internet, and thereby by enforcing copyright, they're enforcing their privacy interest. So that's one way by which these common law copyrights have become prominent in modern times. And there have been a number of similar incidents, even though not successful, with respect to Hulk Hogan, for example. If you remember the story, his lawyers wanted to use copyright to prevent his porn video. So there have been emerging rising interest in the use of copyright for privacy. The other use of copyright for privacy historically has been with respect to unpublished work, which means the author of the work has the sole right to first publication. So what that means is that if someone wants to distribute it, then they can say, no, I don't want to distribute it, or I want to distribute it to specific demographics alone. And that has been used recently in the context of the Meghan Markle. She wrote certain letters to her father, and those letters were to be published by a newsletter, or were published by a newsletter, and then she asserted copyright, but it's not really about copyright, it's about the privacy contained in the letters that the court was relied on. And so she got remedy on privacy. So generally, these privative claims have been dealt with in a very prominent copyright scholar by Dagne in privative copyrights recently. So they are self-standing interests, not attached to the copyright, the copy dimension of copyright, but rather the disseminative aspect of copyright. So if that is the case, then the first claim I make is that users' data privacy in processed and aggregated data can be recognized to the extent that users contributed raw data of different categories. So early use of copyright to protect privacy in the past arose from the private nature of the expressions that induces the personality-infused content, the nature of private communication, instead of the originality nature of the work. there is no requirement of originality of the work. So even though raw data cannot be considered original, then my argument is that if it is too private, there is a basis for using copyright to protect that privacy. So for example, in the past, before the statutory inclusion of these self-standing rights under right of public distribution, copyright was used to prevent the distribution of the private catalog of private possessions. That catalog of private possession doesn't have intellectual feature. It doesn't have originality. But because of the private nature, copyright was used to prevent it. So that is the first claim I make. Then the second challenge for this claim would be, well, how can data be authored if it doesn't fulfill originality requirement? Then my argument is that authorship in data is a complex process. It depends on multiplicity of production methods. Various individuals are involved in the production of data. The farmer who used the tractor to choose which land and what area to record is contributing something. Then once that data is collected into the technology and stored into the cloud, and then that's processed by an AI process, somebody else is also contributing to that data. So the second claim I make, therefore, is that, well, users' data incorporation and aggregated and processed data should nonetheless lead to the creation of a joint authorship relationship between these copyright owners of processed data and contributors of the raw data. Now, how can joint authorship be established? There are a number of analyses I conducted. There is a Goldstein approach and the Niemeyer approach that deal with whether joint authors, each one of them should contribute copyrightable contribution, or would one contributor who hasn't contributed copyrightable or original contribution, but just raw data, would they be enabled to be joint authors? There is the Niemeyer's approach that supports that, even though the majority of courts have adopted the Goldstein approach that each joint author should contribute copyrightable contribution. There is a minority view, still this is a circuit level division in the United States, whereby those who contributed non-original data could also be, if their contribution is an inherent part of what's said to be copyrightable, then they could be joint authors. So if we have that basis as a basis, then the argument is that the copyright can serve as a normative basis. And then what that means is that in a sui generis legislation, data contributors could have certain rights that mimic those of a joint author. So what would be the nature of those rights? Those rights would be covering words of authorship, excluded from copyright statute, that is raw data, but they are structured as private cause of action, which means they are similar to those granted by copyright. That copyright remedy is a very important instrument in privacy doctrine. So if that is the case, what will be the content of rights? At least two minimal rights should flow from this recognition of joint authorship. A right of disclosure is a moral right in copyright, which is not recognized in Canada and the United States, but it is something that enables the control of disclosure to third parties, simulating the working of what is called right of disclosure in moral rights. It recognizes the author as the ultimate judge of when and under what condition a work can be disseminated. So therefore, if a farmer shares their data to a technology provider should be bound by the dictates of the farmer on when that data could be disclosed. That is the right of disclosure. Second, the right of access to data. The right of access to data should also be recognized in sui generis legislation on account of two grounds as a counterbalance to the exercise of access right, justified by the balancing of interests, as well as the promotion of the progress science and fairness in the United States. So what that means, the argument is that there are this right to repair movements right now, which address farmers' interest in accessing data. Those should be broadened, and rather, instead of being restricted to access to machine and device data, they should be enlarged to technical data, enlarge it into activity data, and process data. That should be recognized in a sui generis legislation. So that being the argument, the conclusion draws on this discussion and inquires whether would this preventive copyright framework apply generally to all technology users' data, or would it be specific to either agricultural data or data of economic value in other sectors? Agricultural data is distinct from, let's say, social media and platform users' data. That is where most of the scholarship is concentrated on, how to regulate social media and platform users' data. Agricultural data is actionable data. Social media and platform data is not actionable data, which means it's not daily used for practical and commercial purposes. Second, there is a sense that in agricultural data, to the extent that you have rights to the land, you should also have rights attached to the data. So there is a value attached to the land, and agricultural data will be more properly deemed authored in a sense that there is no completely automated collection. In social media and platform data, the data collection is automated. So that makes it outside of copyright. But in agricultural data, that's not the case. So therefore, the point the paper makes is that this framework would work in raw agricultural data, but it transposed to other categories of data for future research. And that's what the paper is about. If you have any questions, I will be happy to discuss. Yeah. Thank you.
Yeah, thank you so much, Tash, for that really interesting presentation. Does anybody here have any questions, or anybody online? Professor Pillier has a question. Okay. Professor Pillier, please.
Thanks, Chess. That was a very fascinating presentation. And the question that I have goes back to something you mentioned early on. I think you were talking about shrink wrap agreements and the that data about 74%, I think, of farmers in Australia not understanding in a detailed way the content of what they had agreed to. In your conception, your normative use of copyright's normative basis to create this sui generis framework, would that be something that can't be bargained away? I mean, I guess my concern is that a workaround for this is for the data processors to ask or to embed in some of that shrink wrap, efforts to bargain away all of these rights. How is that something that you'd try and prevent by excluding that?
Yes, so that's a very good question, because that is the whole reason why I based the argument on a normative model of copyright. So there is what is called contractual overriding copyright. So there are certain rights that can be overridden through contracts, but the proposal is that this should be a mandatory aspect of the law that should be applied in contractual stipulations that cannot be deviated from, where contractual override will not be allowed. Well, I didn't mention it, but one of the rationales for the proposal is that there is a fundamental power imbalance. There is a fundamental power imbalance. There is information barrier. There is structural imbalance. And to protect farmers, we need to have a mandatory term of law that cannot be contractually overridden. So there are attempts in European Union, for example. The European Union has prepared a contractual code of practice, kind of voluntary arrangement whereby farmers would be helped to stipulate their contractual agreements, but that is voluntary arrangement. There is in Canada, in United States, there is what they call agricultural transparency movement, whereby they will certify some companies who provide clear terms of ownership and transparency within farmers with some sort of certification. That's the voluntary arrangement. It could be surpassed through contractual stipulations. So that one of the key points I make in the analysis is that there is a need for a contractual override and a mandatory intervention in this power imbalance scenario. And that is why this should be structured based as or modeled on a copyright regime, so that like in copyright, certain rights cannot be overridden in contractual terms. No.
Thanks.
No, thank you. No.
Robert.
Okay, thank you. Can you hear me, everybody?
Yes, we can.
Everything's working. Tesh, thank you so much. I really enjoyed the presentation and find it really fascinating, the argument. So you make the case throughout that copyright is a useful analogous framework to draw on. What would you say to the counter argument that it's inappropriate to speak? So it's fair to speak on the one hand of the data being owned by the farmers, the data being owned in this context, but that the analogy of authorship doesn't quite work here because the data itself does not amount to a work, and that if you don't have something like the concept of a work, it's inappropriate to draw on the copyright framework because the entire framework is premised on a series of principles that are designed to protect the system of authorship, publication, and the circulation of works in a market. Whereas, so that you get the gist of my question. So how do you get around that? I mean, the idea that the data it doesn't quite amount to a work. It's more sort of it's not quite random, but it's more shapeless than something like a work.
Right, very good. So that is the argument is the initial point is that under copyright law, data are analogous to facts, and facts cannot be protected as work. Now, so is agricultural data, raw data, facts? To the extent that this data of all those three categories, at least activity data that entered through keystrokes looks like more kind of work. But when it comes to technical data, it is a factual representation of reality. It's about what the soil is or what the machine recorded. So there is no creation, there is no authorship, it's not work, right? So in that context, I'm not arguing that there should be copyright over facts, but copyright has somehow the jurisprudence has evolved in such a way that when this data is moved a certain step, processed a little bit, then there is a possibility for consideration of it as a work, right? But this work is owned solely by upstream actors, technology users, data intermediaries, technology actors, technology owners. So then my argument is that still that raw data is data that's not covered under copyright, but when it is covered under copyright in a processed form, farmers should have some form of legal relationship between these copyright owners and their contribution. And that comes by way of joint authorship. So then the crux of the argument is that when does joint authorship arise? Joint authorship arise, there are two splitted opinions. So we don't know what right now they are, the American Law Institute is preparing a restatement of the law in copyrights. So there is a circuit level division between those who hold that the farmer as well as this third party who owns copyright should contribute copyrightable work to be joint authors, right? There is that argument, the Goldstein approach. Whereas the Niemeyer approach is that if the farmer has contributed something that is an inherent part of more than the minimus of the work, then even if that raw data is not copyrightable, it should entitle them to joint authorship relationship. So if we base, there is a support for this line of argument, even though it's in the minority, there is at least a support to this argument in statutory terms, in literature, as well as historically speaking in jurisprudence. If that is the case, then the argument is that that relationship should be modeled as a basis for some kind of sui generis legislation. So I'm not saying farmers should be actual joint owners, but that level of relationship in copyright law, that existing relationship in copyright law should entitle farmers to certain rights that naturally an author would have, right? So that is how I try to create that argument. So historically speaking, in these privative copyright claims where privacy has been, or data privacy has been protected through copyright, wealthy individuals who have a catalog of resources of various goods, they protect it, they prevent the publication of that list, not because that list has any intellectual content, but because it is private nature. So if we have to rely on that normative model, then there is a basis for that level of joint authorship kind of relationship. And that should translate into a sui generis law that results in some rights. That is the line of the argument. Did I respond to your question, Robert?
Yeah, that's great, Tesh. Okay, can I ask one follow-up? Unless
sure,
yes,
yes, yeah.
I want to say that an analogous argument has been made about our data ownership, our ownership of data, and the possible assertion or recognition of some right or interest in the data that then gets used by Facebook, Google, etc.
Yes.
The Cory Doctorow argument, others have made this argument that we should either be compensated for it or we should be given credit for it in some way. We should be, there should be some recognition that our data, the data we generate is a form of capital, and that, there should be some compensation. So have you drawn in any way on thinking about how rights or interests may be structured in that context, in the farmer context? And also, I'm also curious, if you haven't drawn explicitly, is there any obvious difference between the kind of data that we generate? Like, so for example, like I'm fascinated by the point that you made that, when the farmer is driving the tractor around, he or she is not just generating facts, but they're also sort of generating an interpretation. They're generating more than can be gleaned by, say, satellites or something, or sensors that the choices they make, the practice of how they're going to move, the tractor, or the fact that the sensors are picking up the way they've chosen to grow and what they've chosen to grow and so on. All that is all that special information, and that that's worth something. So there's that's going on in the farmer context. How is it different when you look at what we generate? So when Google, for example, harvests my data, what other differences are there? How is it helpful or not?
Very good. So with respect to the first question, observation, that's a very good observation. There is a lot of literature built on what is called a trust model. So my argument is based on a trust model in that context, to the extent that those who take our data, there is a lot of argument with respect to platform and social media data, right? Those who take our data should be trustees, and then we should be beneficiaries. So then there are different models, right? So the common law trust relationship is invoked as reduces that relationship in some contexts. In other contexts, some form of compensation based on condition of labor is espoused. There are a number of lines of arguments. So my argument actually lies within that category, in the sense that to the extent that these technology owners, data intermediaries, upstream actors own our farmers' data, they should have some level of obligation to the data originators. Now, how should that be structured? So some would look into the traditional trust model in the common law and look into beneficiary trust, beneficiary relationships, some into liability. So that there is that vast area of scholarship, and I'm familiar with it. And mine is just simply asking, could corporate provide a similar remedy or a similar relationship? Could corporate be used to structure a similar line of rights? So that is where my scholarship falls. With respect to your second question, so there is that is probably something I will explore in the future, in a sense that we don't, well, when we engage in social media data, in our social media, we do our things, right? We don't intentionally create data. Well, the farmer actually is also doing some economic activity. They don't necessarily intentionally create data, even though they are aware of the data generation capability of their instrument, because they bought that tractor for that purpose. But the more significant difference for me is that in terms of need, do we have, first, there is a significant economic interest attached to agriculture as an economic activity, or if it's in the health sector, to the doctor in relation to the technology, right? So there is a significant economic interest that goes beyond privacy interest. In our social media and data platform data, the interest is more privacy. The harm is more kind of emotional nature of harm that would result upon the transfer of the data to third parties, right? Largely, that is a concern, at least in the literature. So to that extent, that is where I ended up saying, could this be generalized, right? Could we have a general framework of data in general under this framework? That I'm not sure, but there is some level of distinction between agricultural data and social media and data platform data. To the extent that we produce data, it's an automatic generation, but in some cases in agricultural data, it seems to be conscious generation, right? Consciously, they will input their data, they will register the number of feeds provided, the type of agricultural input, etc., at least with respect to activity data. So to that extent, there could be differences in terms of framework.
Maybe I could jump in with a question here. Now,
sure, yes.
This is a little bit out of my depth, Tash.
Yeah.
But in your presentation, I felt that a lot of the focus was, I mean, obviously you're looking at how to define the nature of the interests of the farmers. And there's this, in the copyright context, as I understand, there are rights, entitlements of an individual within that context are recognized in the theoretical stuff you're talking about, yeah, which is involved in what we know as copyright law now. But one of the other theoretical dimensions of it, at least that I, and this is where I'm kind of out of my depth, that I think is also present, is that copyright evolved in order to try and encourage the development and sharing of this kind of information. And so I'm curious about if a recognition of ownership in some degree, like you were suggesting, of the individual farmers, like whether that could sort of like have the negative effect or go against that, the openness, like the purpose of opening up information by basically kind of creating like some type of veto power that farmers would have. So it would really undermine the whole purpose of the value of collecting this data and using it in a broader way. So I'm just curious if you thought about that, how does that kind of fit into what you're arguing for here?
No, that's a very good question. And that's really where I initially laid out the framework, right? So the whole purpose of this exercise is to create trust in data sharing, not in exclusivity, right? So the problem is that right now, farmers or other actors are hesitant to share their data because they don't have access to it once it's transferred, and they don't know where it will go later on once they lost control, right? So this framework, to the extent that it ensures these rights, the whole purpose is to create a trust relationship in data sharing. Data is best utilized and best exploited as an aggregate than in silos, in individual form, whether in the context of the general farmer population. So the question then is, what basis do you give these farmers so that they can freely share their data, knowing that they have these legal entitlements, right? So to that extent, it goes in line with that copyright's purpose of distribution, free sharing, and dissemination of knowledge and resources. But I agree with you. There is also a concern that these two are disparate regimes. Privacy frameworks and copyrights are disparate regimes. And to the extent that you assert privacy, you defeat the purpose of copyright. But there is a level of, within copyright law, there is an inbuilt recognition of some level of control that goes against that free dissemination concept, what Dagne referred to as disseminative harm, to prevent disseminative harm instead of copying harm. So to that extent, it's consistent within the doctrine of copyright, and to the general framework of creating trust relationship. It also serves as a basis for data sharing. So my approach is we should have a guarantee that encourages farmers to freely share, knowing that they have these rights. So that is how I see the two will be consistent. Right.
Looks like Rob has a question. I assume it's something about trusts. Is that right?
Okay.
Yeah, thanks very much, Tester. Really enjoyed that. And it's a question, as the little bit I know about copyright, I always think of it as protecting the form of expression rather than the ideas expressed. But I was wondering, in terms of giving farmers control over the information, would there be any room to develop the law on breach of confidence and confidential information to give them that control? Because you're talking about the trust relationship, and
right.
A lot of the confidential information cases are all about someone trusting someone with some information to be used only for particular purposes. Thanks.
Right, very good. No, that's I have briefly looked into that, and one of the challenges then is, in actual terms, in the relationship between farmers and these technology providers. One of the stipulation is that there is no expectation of confidentiality in data sharing. In these clip wrap and contractual arrangements, they clearly absolve the data collectors from any obligation of data sharing. So to the extent that there is no expectation of confidentiality or mechanism of confidentiality or ensuring reasonable expectation of confidentiality, then that probably wouldn't be too much of help. But I think that is also one arena where, at least in the common law context, farmers could carefully craft their terms of engagement and ensure that terms of confidentiality and reasonableness are ensured. So there is some level of work exploring that as well. But from the contracts I reviewed, that expectation of confidentiality is totally, there is no mechanism of ensuring a level of confidentiality in the contractual arrangements. So that basically defeats the goal. But I think that is one avenue as well. Trade secret law, there is some level of control to be made in that respect. Yes.
Thanks, Tesh.
Thank you, Rob.
Yeah.
Anyone from the room? Yes.
In the room here from Jeffrey.
Hi, Tash.
Jeffrey. Hi.
Sorry I walked in late, so forgive me if this question reveals that fact. I thank you for your presentation. I thoroughly enjoyed it. And I guess my questions are a bit in the same vein, I think, as probably as Professor Diab, Professor Blair, some of the same themes I want to tease out a little bit from your presentation. And so first thing I'll say is I like the thing that's quite interesting about your research is how you're unpacking the intersection of three crucial concepts, one being privacy, the other being copyright, and the other being data, and the kind of intersection of those three things in the lives of people who are basically subalterns, right, who are not normally part of the discourse around copyright. So I think that in and of itself is it has a kind of emancipatory potential for the farmers. So I like that, right? But I want to think about, but I also, when I'm listening to the presentation of your research and the way, one of the things I'm thinking that I'm hearing echoes of in the research, and forgive me if I shouldn't be hearing those echoes, but I think what I'm hearing echoes of is some of the critical treating contemporary neoliberal capitalism as as parasitic, like capital now being kind of a parasitic, almost like vampire capital, and then. And so that again, maybe in the early 2000s, when we had this kind of more idyllic view of what this model of labor and extraction would look like in globalization with the internet, we thought it could be very freeing, right? The idea of like a renewed commons, and then everyone were talking about kind of immaterial labor with people's generation of data or knowledge, but obviously also a real material element of this for these farmers, right? So I wonder if you want to comment on the politics of it generally, but also more specifically, if anything's lost by framing these kind of potentially emancipatory discourses in the language of private law and copyright rather than, for example, workers' rights, right? So I just wondering for your thoughts on that, Tash. I'd be so grateful to hear.
No, very good. So that touches on something I mentioned in the footnote as well as later on, which is, presently, farming agriculture is a corporate practice, right? There are huge, this paper doesn't deal with the industrial sense of that corporate farming practice. It looks into small scale farmer and family kind of situations. Now, another aspect of this would be, would this be the right of the landowner? So let's say, for example, if a farmer is renting their land, right? Would this right, the data collected from the land, be owned by the landowner or by the farmer? From my perspective, the originator of the data is a farmer, and that plays into that power dynamic. So let's say farm workers, right? They have all different kinds of technologies in working in the farm, and lots of data is generated from their activity. So who has privacy and economic interest over that data? The workers or the farmers or the contractual corporate agricultural enterprise. My approach is that has a very private and personal implication that relates to the farmers, to workers as farmers on the farm, right? So there is that level of, in some part of the paper, I look into how these agricultural input providers, seed providers, and actually agricultural actors are consolidating and collecting. Bayer is purchasing, a Climate View. Climate View was a corporate farmer that utilized certain technology on their land. So there is that level of concentration. And to the extent that there is that level of concentration in the form of capitalism, this framework wouldn't work. I look into the bottom-up kind of farmer worker, small farmer kind of remedy. Otherwise, the dynamic is different in terms of corporate industrial farming. The relationship is totally different. It's outside of this framework.
Yeah, this is more a medieval kind of, again, sometimes it's like it's more of a medieval than a modern situation.
Right. Sorry, I didn't hear you clearly.
In some ways with these small farmers, right, these relationships,
right.
They have more of a medieval kind of character to them than like.
Right.
Yeah.
Yeah, that's right. Yeah.
Thank you very much, Dash. I really appreciate it.
Thank you, Jeffrey. Yeah. All right. Anyone from students?
Yes, please. Thank you, Professor. My name is Michael. I just had a quick question about kind of the farmer's role with data, more of from a practical sense. Do farmers have the capability to like really act on the data that they produce, or like how like they might visualize it, or just make it actionable? Is that something that farmers currently have the capability to do at the moment?
There is a lot of, when you talk about farmers, it's just a group, right? There are lots of consultants. There are lots of IT consultants, agronomists that help farmers visualize their data, process their data. So they hire, in a single family firm, that capability may not exist, but there is a significant amount of IT consultants, and in some cases, industry representatives that help farmers. So, we are talking about farmers as an interest group. So would their right of access apply to the agronomists they hire? Yes. Or to the IT consultants they hire? Yes. So it's in that context that farmers utilize data mostly in the present times. Unless it's industrial setting, a farmer cannot be self-sufficient to actually, in many cases, they may not have the capacity, but they increasingly hire these consultants. But these consultants are confronted with this corporate control of data. So they have to pay a fee, or they can't make the best farming decision, and they are confronted with what is called data drought. So yeah, there is a level of capability in that form, in that way.
Thank you.
Yeah, thanks.
Yeah, I do have a question. I was interested in like your characterization of what you were calling upstream actors.
Mm-hmm.
Context, I don't have much of a background at all of understanding the project, but I really appreciate the presentation. And so I was wondering, is it currently possible, or is it currently happening for those upstream actors to be using copyright law and protection of like the collected data?
Yes, so these upstream actors are, in many cases, technology providers, right? So John Deere would provide the harvester, and then would have a software capability with that tractor that collects data, and then John Deere would make that data accessible to the farmer through further subscription. Right? Or John Deere would create an agreement with a Bayer or Monsanto, so that Monsanto or any of their subsidiary would use that data to prescribe a particular kind of agricultural input to the farmer, or to advertise to the farmer, right? So those are what I call upstream actors, are, those below, above the, so there are these data originators, farmers, then technology providers, then in some cases, technology providers may sell the data to data intermediaries. Data intermediaries are basically data brokers. They kind of sell data to whoever is willing to buy. So if a futures trading company or future traders want data on next year's harvest, they will contact the data brokers. So there is that level of use, but the concern is as these upstream actors get into more data access agreement and into consolidation amongst each other, from farmers' perspective, they become the wield influence and power. So yes, there is a significant level of data control by upstream actors, by technology providers mainly, but data providers, data brokers, data intermediaries, and other actors as well.
So they're essentially using the law of copyright now to copyright data that's originated from farmers and then sell it back to them, basically, like as if it was not originated by them.
Yes, so they use, so they have software control, right? So they have copyright protected software that controls the data, right? So access to that software will be available through subscription. So that is an exercise of copyright by itself, or there is technological protection measure over the data, and access to the data would be granted if the farmer subscribes to it, or if the farmer, just like the story of those farmers who hacked their tractors, right? If the farmer want to get around, they have to circumvent that technology protection measure. But copyright enables them to control the data through technological protection measure. Second. Thirdly, they get into copyright exercise through contractual stipulation, right? So even though the data may not actually be copyrightable, they assert copyright through contractual stipulations, and those contractual stipulations, to the extent that farmers sign them, they'll be bound by them, right? So that's the third way. Fourthly, well, there is a level of jurisprudential change that relates to process data in which copyright is recognized. So in all these all four ways, copyright plays a role, and actually these clip-wrap agreements are means of exercise of copyright from upstream actors' perspective.
Okay.
Yeah.
Thank you.
Yeah, you're welcome.
Hi, Professor Greg. I was wondering, how much weight do you think should be placed on the intention behind collecting the data by the service provider, and whether or not they're collecting it to provide a better service to the user versus possibly selling it to a third party for use in advertising or something like that?
Okay, sorry. Can you repeat, or can you get closer? I didn't hear you very clearly.
How much weight do you think should be placed on the intention behind collecting the data of the service provider, and whether or not they're collecting it for their own personal use to provide a better service to the user versus selling it to a third party for advertising purposes?
That's that is the more serious concern, the second aspect of use of data, right? Transfer to third parties, right? Because once transfer to third parties, we don't know what would happen, right? It could be sold to competitors who would know the next year's harvest by a competitor, or it could be sold to future traders. It could be sold to advertisers, as you said. So I think between guaranteeing access to provide better service, that I think is legitimate, which farmers would voluntarily share data with. But the second aspect of data sharing to third parties, that is a significant concern. That is what led to an actual litigation. Well, it's an antitrust case, basically an antitrust case based on an allegation of collusion between the data provider and chicken processors. And there have been a number of allegations, but basically that is built based on access to data transfer to third parties. That is a more serious concern. If the farmer, if the technology provider, if John Deere is collecting data to provide better planting advice in a reasonable fee, or data access doesn't mean free access. Access right to data doesn't mean free access. Access through reasonable pricing, that I think is acceptable way of using data. But that transfer to third parties is a more serious concern that has resulted in actual litigation, at least in the United States, and which is a concern for many farmers because it touches on their economic survival, just not only the privacy dimension, but the economic harm that results from their means of livelihood.
Thank you.
Yeah, you're welcome. Yeah. All right.
Okay. I don't think there's any other questions in here. Why don't we thank Professor Dagne.
Thank you, everyone. Yeah, thank you.
All right, well,
All right.
everybody for coming. Thank you, Tesh. Do
Thank
you have
you.
any other last words? Do you want to is there sort of something that you wanted to leave imparting wisdom? Oh, it looks like, sorry, was that clapping or is that a hand, Robert? Clapping.
It was clapping. It was clapping. All right. All right. Thank you. No, thank you very much. I am right now in Addis Ababa in Ethiopia. I plan to come back to Kamloops next week, and then hopefully this research, an aspect of this research is published, will be published, but I plan to develop it into further work, and I hope to share more broader questions and just more of the future research at some point in the future. But this is a new territory I got into, and I'm learning more, and I'm reading more, doing more research, and hopefully we will have more discussion in the future. So thank you everyone for coming. I really appreciate it, and I enjoyed our conversation. So thank you.
Okay, well, thank you. So just before we log off, just want to thank you all. I know some of you have come to multiple presentations. Thank you to Tesh for presenting and sharing his work with us today. I just wanted to signal that we're going to have more of these presentations again next term. And so information about the dates and who will be presenting will be shared probably at the beginning of the term next year. If I give it to you now, we'll all forget it by then. But do keep your eyes open for it, because I think that these types of engagements are so enriching to be able to hear some of the exciting and interesting things that are being developed by some of our faculty members. Okay, so thank you again, Tesh. Thank you all for coming.
Thank you.
I hope you have a wonderful rest of your day.
All right. Thank you. Have a good night. Have a good day. Well, it's night here.